It is good that most people will never have their daily lives disrupted by a serious crime. However, the few who do often find themselves unfamiliar with the nuances of the legal system. That can frustrate and confuse victims. It can have the same effect on everyday citizens who are simply trying to understand the procedures in a high-profile case. Welcome. My name is Jeff Kidd, and I'm the Administrative Chief of Staff at the 14th Circuit Solicitor's Office. We bring to you this video series to explain the criminal justice process in the 14th Circuit and to make the confusing clear. In this second episode, we explain the requirements of a lawful arrest and the role the solicitor's office plays in the early stages of a criminal case. Before a suspect can be arrested, law enforcement must have probable cause to believe a crime was committed and that the suspect is responsible. If the criminal act happened in the presence of a law enforcement officer, no warrant is needed to make an arrest. Otherwise, an officer must convince a magistrate to issue an arrest warrant. To do so, law enforcement must satisfy the probable cause standard burden of evidence. This means police must present facts to the judge that would lead a reasonable person to believe the accused likely committed a crime. This threshold, while higher than mere suspicion, is lower than the beyond a reasonable doubt standard that the solicitor's office must meet to earn a conviction. In fact, prosecutors shoulder the highest burden of proof in the criminal justice system, which is as it should be when you're empowered to take away somebody's liberty. It is an awesome responsibility. Though not required to do so, law enforcement agencies sometimes seek legal opinion from the solicitor's office before deciding on an appropriate charge or whether to make an arrest. In such instances, our office's advice will be based upon the beyond a reasonable doubt standard that we must meet. Law enforcement agencies are not obligated to follow our advice, however. They make their own independent charging decisions. Also, during an investigation and before an arrest is made, law enforcement agencies sometimes ask for help from solicitor's office investigators. For instance, we often extract information from cell phones, surveil suspects, or help agencies collect evidence at crime scenes. Our investigators are duly sworn law enforcement officers, and we generally honor such requests for assistance. However, our investigators are not patrol officers, and they do not typically conduct independent pre-arrest investigations. As such, citizens who suspect criminal wrongdoing should make their report to a law enforcement agency with jurisdiction where the activity took place. Similarly, neither our investigators nor our attorneys typically bring initial charges against the defendant. In South Carolina, that is done by law enforcement, with rare exceptions. In our next video, we will explain what happens in a case after an arrest is made, the action that really springs the solicitor's office into action.